The Texas Code of Criminal Procedure clarifies some details regarding an arrest made under warrant. These are fairly straightforward, but it's still important to be aware of them. First, the Code of Criminal Procedure specifies a person is arrested, or in other words, considered to be under arrest, when he or she has been actually placed under restraint or taken into custody by an officer or person executing a warrant, or by an officer or person arresting without a warrant. Take note, this addresses when an arrest is made statutorily speaking. This is just one of two pieces in a legal determination when a person is considered to be under arrest. The other portion involves case law, or the prior decisions of courts, as to when a person is reasonably considered to be under arrest. Next, according to the Code of Criminal Procedure, an arrest under warrant may be made on any day or at any time of the day or night. You may question why the CCP has to be explicit in something that seems to be common sense. But remember, essentially, in making this type of arrest, the peace officer is executing or serving a writ or legal document, namely the arrest warrant. There are other legal writs, primarily certain civil papers, that have restrictions when they can and can't be executed or served. For instance, according to the Texas Rules of Civil Procedure, a certain type of legal writ called a citation may not be served on Sundays. Next, the Code of Criminal Procedure states, in making the arrest, all reasonable means are permitted to be used to effect it. However, no greater force shall be resorted to than is necessary to secure the arrest and detention of the accused. The Code of Criminal Procedure goes on to state, in case of felony arrest warrant, the officer may break down the door of any house for the purpose of making an arrest if he be refused admittance after giving notice of his authority and purpose. Again, keep in mind we're talking about felony arrest warrants. There is significant additional case law regarding a peace officer making a forced entry to execute a felony arrest warrant. In addition, individual agencies more than likely have significant policy and procedures governing when and under what conditions a peace officer can break down a door. Next, in executing an arrest warrant, it shall always be made known to the defendant under what authority the arrest is made. The warrant shall be considered executed by the arrest of the defendant. The Code of Criminal Procedure is clear. The officer need not have the arrest warrant in his possession at the time of the arrest, provided the warrant was issued under the provisions of the Code of Criminal Procedure. But, upon request, the officer shall show the warrant to the defendant as soon as possible. The Code of Criminal Procedure goes on to state the officer who does not have the arrest warrant in his possession at the time of arrest shall inform the defendant of the offense charged and the fact that a warrant has been issued. So again, it's almost common sense that a peace officer is likely going to be made aware of the existence of an arrest warrant from his or her dispatcher, or maybe by telephone communication with another agency, and won't have the actual piece of paper in hand. The CCP states having the actual paper in hand is not necessary. However, the peace officer shall inform the arrestee of the fact that there is a warrant for their arrest and notify them of the offense for which the warrant was issued. If the arrestee asks to see the warrant, the officer shall show it to them as soon as possible. Finally, the arrest warrant and any affidavit presented to the magistrate in support of the issuance of the warrant is public information, and beginning immediately when the warrant is executed, the magistrate's clerk shall make a copy of the warrant and the affidavit available for public inspection in the clerk's office during normal business hours. Any person may request the clerk to provide copies of the warrant and affidavit upon payment of the cost of providing the copies.